website. So for anyone who doesn't have the chance to join today, you can always direct them to that if they're curious about seeing this presentation. So my name is Ashleigh Dougill. For those of you who I have not had the chance to meet, I specialize mostly in public contracting and land use issues at Barry Elsner and Hammond, but I also handle a little bit of everything public entity related, just like everyone else on our team. Today, I'm going to be presenting to you all regarding essential elements to look for, specifically with a focus on goods and services agreements. This is a 201 training, so last year I did provide a brief introduction to procurement processes and general contract types that you see in public contracting. That is posted on our team website. You can reach out to our team for the link to that. I'm also happy to provide that to you as a specialized training for your particular needs, if that's an interest for you. So, our goals for today. As I mentioned, we're trying to primarily focus on learning and understanding some essential elements of a contract through a goods and service lens. And the reason I'm focusing on goods and services in particular is because these are by far the most common contracts for public entities, and also, at least for goods agreements, they are the ones that come across our desk as legal the least. It's the ones that I see public entities negotiating on their own the most. So because of that, I think it's helpful for you all to have a basic understanding of all the key terms that you would see in these agreements and be able to negotiate them on a base level on your own behalf, and then of course understand when to come to your legal team for assistance. Also, this presentation is very general. It doesn't represent all terms that may be included in a specific contract. So again, if there's something that isn't covered here, always feel free to reach out to our team for further questions. I will also be saving some time at the end of the presentation, ideally for you all to ask specific questions. So please feel free to hold your questions till the end. So before I get into the elements of these goods and service agreements, it's important to understand what is a contract. A contract is an agreement between two parties that creates an obligation to perform or not perform a particular duty. In order to have a contract, you need three elements: offer, acceptance. So offer is just an offer to perform or do something. Acceptance is accepting that offer. And then consideration. That means something exchanges hands in consideration for this offer and acceptance. Most often that is money, but it doesn't have to be. If you have these three elements, offer, acceptance, and consideration, you have a legally binding agreement. Notice here that one of the three elements is not that it's written. That means that you can have a legally binding agreement even if something isn't written down, just a verbal agreement, or you can even have something that's legally binding that's just maybe a written document that isn't quite up to the standards that you would like for a contract. So that just means that anytime you're signing a document on behalf of the city or your public entity, we just recommend stopping and thinking, are you actually entering into a contract? Is this something that maybe you should seek higher approval for or get legal involved on? And to illustrate this point a little bit more, I have a hypothetical for you all. So in this hypo, a sales rep reaches out to you. They heard that your department is in the market for some new maintenance trucks because your current ones are nearing their expected life. They provide you with a quote, which seems promising. You decide that your city could do a trial run to test their product, and you purchase one truck. The one truck is less than $25,000, so per your state procurement and also your local procurement rules, you're able to purchase this directly without completing a solicitation. Given the lower value of this purchase, you want to avoid the administrative hassle and paperwork of signing a contract. Therefore, you simply ask the sales rep to send you a purchase order and an associated invoice to sign. You've successfully avoided the time and effort of negotiating and executing a contract and all corresponding legal problems, right? No, unfortunately, or else if only it was that easy, right? But you've probably still signed a contract just according to that truck company's terms. I'm sure you all have seen something that looks very similar to this invoice that's on the screen here. This is just an example of a sample invoice that I found online, but you can see here, this follows a very standard layout for invoices, where you have the payment terms up above, net 30, meaning payment is due within 30 days, the invoice date, etc., the value of the items provided. And then you have this button down here at the bottom that says, I accept all terms and conditions pertaining to this transaction. And then you click that little button. I'm sure we've all done that when we've purchased things online for ourselves personally. But what you're doing when you're clicking that button is you are agreeing to define terms and conditions, which is a term of art, which refers to basically the meat of an agreement, the body of a contract. And it's common practice for these private entities to basically take out all the favorable terms and conditions of an agreement, add that to a PDF, and then save that as their standard terms and conditions on their company website. When you are clicking this I agree to terms and conditions button, you are stating that this invoice is subject to all of those terms and conditions that are laid out elsewhere on their company website. So even though on the surface, it may seem that you're just accepting a one-page invoice, which is fairly, administratively simple, you're actually still agreeing to a full contract, most likely. This is just another example of what an invoice can look like and how terms and conditions can be drafted in an invoice. Here, it's a little bit more detailed. There's a few more specific terms and conditions in the invoice, but you can see at the very end, it still refers to terms and conditions of the seller, which is implicitly listed on a separate website. And then just to further drive that point home, this is an example from Johnson & Johnson's terms and conditions that they have on their website. This pertains to all purchase orders, general purchase orders that they execute. So anytime someone purchases a good from Johnson & Johnson, there's a 4-page double-columned PDF of like 8-point font, you can see from this example, and it contains all the key terms that you would expect in a goods or service agreement, just nothing that is public entity favorable or required for public entities. So again, it's just important to keep this in mind when you are signing those purchase orders. The takeaway from this, even if a product has a relatively low value, please consider using a city contract template, or at least, giving it thought if that may be necessary. If you are signing a purchase order or other invoice, you are signing a binding agreement, and it likely includes terms and conditions. And just remember, binding terms and conditions are essentially the elements of a contract. All right, moving on to the actual meat of this presentation. These are an overview of the essential elements of a goods or service contract that I would expect to see. I have broken down this contract into various sections or categories. These include the introduction sections, then the body. The body is where you would find the main substance of the agreement, more of the substantial terms that you would be looking for when you're actually negotiating your contract, such as what goods or services you're purchasing, what the value of the agreement is, how long it's in effect, etc. Then you have the legal terms. Those are things that you would hopefully ideally involve your legal team to negotiate, but they're still important to have a base understanding of, followed by miscellaneous and boilerplate provisions. These are typically the same from contract to contract. And then finally, signatures and attachments. So just another really quick background. There are many other types of contracts beyond goods and services. There are plenty of other types of services beyond just simple general services. There are also public improvement agreements, which are generally construction, reconstruction, or major renovation. This presentation, again, just focuses on general services and goods agreements. There are also a number of contracts that are not subject to any public contracting rules, but may still require negotiations or certain public contracting terms. This is a non-exhaustive list. There are more that are set out in state law. Again, my prior presentation about procurements and public contracting types goes over all of this, but this is just a brief reminder. All right, so In that first category of introduction, which is the first part of an agreement, ideally, we have three initial categories, which is your preamble, your recitals, and then your transition clause. This does not always look the same, and it's not always labeled in every agreement, but generally you should aim to have these three elements addressed in every contract. This really sets you up for the rest of your agreement. It provides background, introduction to the parties, etc. So the preamble takes the form of an introductory paragraph right at the beginning of the contract, right below the title. It usually includes your contract name, the parties to the contract, effective date, purpose, etc. Following this little preamble paragraph, you have what's referred to as recitals. This provides background to your contract. People also refer to it as your whereas clauses. I'm sure you have experience with this in the context of resolutions or ordinances. You have the intro part of your resolution or ordinance where you lay out the background or context in whereas clauses. It's very similar for a contract. It's important to note, though, they don't always take the form of whereas clauses. You can easily just draft your recitals as a paragraph or a sentence. That's just one of the common ways that it's referred to. Recitals are not enforceable. That's important to remember. It's just providing context or background, unless they're expressly incorporated into the body of the contract. And then following your recitals, you have a transition clause. Usually that is marked by now, therefore, and following that transition clause, the actual body of the contract begins. So to illustrate this further, I'm going to be walking through that goods or service template contract that I mentioned, and here is the intro section of that goods and service contract. So you can see here we have the title, followed by the preamble, which is setting you up. Again, it's providing the introduction and background to who the parties are, the title of the agreement, etc. It looks like for this one, the effective date is probably defined elsewhere in the agreement. And then it has a really simple recital section here, no whereas, but it's still the recitals because it's the background on why the parties are signing this agreement in the first place. In this case, it's very simple. It's just that they believe it's in their respective and mutual interests to sign an agreement, laying out their understandings. Recitals can be as simple as that. And then you have your transition clause, which states now, therefore, that's how you see that it's your transition. And below this would be your actual body of your contract. So another introduction or section of a contract that I would consider part of the introduction is conditions precedent. Conditions precedent are a condition or event that must occur before the parties are obligated to perform under the contract or before the contract may even be effective. Conditions precedent are not present in every contract, but I still think it's important to understand their meaning and mention them in this presentation. Conditions precedent are most common in real estate transactions, land use, and financings. To give you an example of a common condition precedent, I'm sure you all see in loan agreements. Often you will execute a loan agreement, but within the provisions of that contract, it states that the loaning entity does not need to provide you with the money until you receive authorization from your public entities board, until you provide some sort of legal opinion on the validity of the documents, and other steps that you have to take. So those would be considered conditions precedent to the obligation of the financer coming into effect. Before they can actually provide you those funds, you must do X, Y, Z. That's a condition precedent. So best practice is just to clearly draft those conditions themselves. Make sure you understand what they are, you understand what it takes to fulfill those, and when they are complete, so that you know when the actual terms of the contract are commencing. All right. Moving on to the body section of the agreement. So just as a note, again, the body is where the main material terms of the contract will take place, the part that will be most negotiated by you all as staff or as individual members of the public entity. The first section of the body that's important to address are the actual goods or services that are being obtained and the compensation for those goods or services. When you are setting out the goods or services that are being obtained, it's important to describe these with sufficient specificity. That means stating if it's goods, how many are being purchased, what exactly is being purchased, whether that is something that's mass produced or maybe is tailor-made just for you. If it's services, it's important to understand the scope of the work. If there are certain project deliverables throughout the time of the scope, and more. Typically, the goods description or the scope of work is held within an attachment to the agreement, just because that's easier to spell out all those details in an attachment. When it comes to compensation, it can also be a separate attachment, or it can be within the body of the agreement, depending on the complexity of the compensation. These are just some of the standard compensation structures that we see and things that are important to include in your compensation section. So here is an example from this agreement, again, of both compensation and a brief reference to scope of work. You can see in the first sentence there, it references that the contractor will perform the work or deliver the product described in Exhibit C. That is, referencing a separate exhibit where the work or the product will be further detailed in sufficient specificity. And then it moves on to discuss the payment structure. It has a total not to exceed amount for the contract. It also has detailed payment terms regarding hourly rates. It says that those are specified in that exhibit as well, and preferred method of payment. And this is an example of a more complicated payment structure for goods specifically. An example of just what this can look like. In this case, they have a more tailor-made piece of goods, and the public entity is more invested in manufacturing, delivery, installation, etc. So because of this, they want to guarantee that payment is conditioned on each of those milestones being completed. So that is another, structure that you can take. It's a little bit more complicated. And if you're trying to, if you have a tailor-made piece of product or something that's more high value, we always recommend just reaching out to your legal team to discuss how best to address that in your contract. All right, moving on to term. So term is another important piece of the body of your agreement. Your term is basically the life of your contract. It is how long the contract is in effect. You most often see a fixed term, which means you have a start date and an end date. Most often your start date is the effective date of the agreement, and the end date can be expressly defined as a specific date, or it could be a period of time. So it could be, 5 years from the effective date, for example. You can also build in options to renew following the end date. Or just an automatic termination, meaning that upon the end date, the agreement is done. We generally discourage indefinite terms just because they are unpredictable. You don't know, where you and the contractor are at now, but who knows how circumstances will change cost, how they will change the actual people who you're working with at the contractor's business, etc. So at minimum, we always recommend that you at least build in the ability to periodically check in on the contract's terms and renegotiate the terms periodically if necessary. It's also important to consider if any contract sections should continue after the end of the term has expired or terminated. Even though your obligations are complete under the contract, there may be continuing obligations that result from the contract itself. For example, record keeping. Often, public entities and the entities that they contract with are required to keep records for a certain period of time following contract expiration, most commonly 3 years, but it depends. So it's important to call that out in your contract to show that even though the contract has terminated or is expired, those obligations will continue. There are many others that you can decide to call out on a case-by-case basis as well. So this is just an example of a very simple contract term. You have the effective date and the expiration date expressly stated. And then you have a little catch-all at the very end, which says that even if the contract expires, this does not affect the parties or the city's right to enforce that contract in connection with any sort of default or defect. So basically, that section is preserving the city's right to make those sort of claims. The right to preserve any other sections would be expressly called out in those sections throughout the agreement. All right, project schedule and delivery schedule. This is another key thing to ensure that you're at least considering if timing is important for your project. Once you have decided what goods exactly or what services exactly you are purchasing, you also should consider, is there a timeline associated with this goods or service delivery or end date? Are there potentially state or federal funds tied up in this project that requires some sort of timeline, etc. For goods in particular, there are two common acronyms that you will often see associated with goods delivery and the project schedules there. Those are FOB and CIF. FOB refers to free on board, which means that ownership of the goods transfer once the goods enter the carrier. So that is a lot more risky for a public entity. That means that you are taking ownership and risk at the minute that the goods enter transportation. In contrast, CIF means cost, insurance, and freight, which means that the provider carries liability for goods until they're in the city's possession. This is my strong preference. It means that they carry risk and title until the minute that they're in your physical possession. Those are common phrases, common acronyms that you see in the context of a delivery schedule for goods. In the context of services, it's important to consider, like I said, what are the actual project deliverables, and are there any specific dates that you need for that? As far as location, for services, you typically see those within the actual scope of work, that separate exhibit. And usually the completion of the services are just tied to the contract expiration to make it easy. So by the time the contract expires, those services should be complete. For goods, you often will find the delivery schedule either in the body of the contract or in an attached exhibit, just depending on how complicated the structure for delivery is and how important specific milestones throughout that delivery schedule are for this particular good. So this is an example of a very simple delivery schedule for a good. In this case, it's probably a good that's mass produced. It is less important the actual timing of each of those milestones throughout the potential project schedule. Really what's important to the public entity at the end of the day for this particular good is just that they receive it by a particular date. So in this case, the delivery schedule is very simple. It just says that the contractor will deliver the goods, CIF, which again means that the liability and title does not transfer until it's in the city's physical possession, by express date. So it also clarifies in this section who bears the cost of packaging, transporting goods, etc., which is important to call out in delivery as well, if there's any sort of question. All right, so these sections, once you have a set project schedule, there are certain situations where you may be excused from complying with that schedule, ways that you update your contract following that excuse, and just ways that you change any other time you want to change your agreement. Because life happens, right? You might have an express schedule, but there might be valid reasons for not being able to meet that schedule or needing an adjustment, a minor adjustment to the contract price as a result. So there's mechanisms for this built into contracts, the first of which is called force majeure. Force majeure means, it's a phrase that means greater force in French. In the past, this concept was referred to acts of God. You can also hear that as a common way of referring to force majeure, but nowadays we just usually call it force majeure. Force majeure means unforeseeable events that are outside of a party's reasonable control and affect their performance of the agreement in some way. So most often force majeure comes up in the context when you have a really strict delivery schedule or project schedule. And because of some unforeseeable event outside of the party's control, maybe delivery is delayed and they need to have an excuse for not being able to have delivery on time. Force majeure can include your typical fire, famine, flood, but it can also be civil unrest or civil disturbances. It can also be pandemics, etc. You can imagine all the sorts of unforeseeable events that can happen. And the result of claiming an unforeseeable event is that if a party successfully claims force majeure, then that party is not responsible for contract schedule delays and possibly not responsible for resulting increase in project costs, depending on how the agreement is drafted. So that's your excuse for not meeting the schedule. But then how do you ensure that the contract actually accurately reflects that change, that excuse? Typically, that is reflected via a change order. So a change order is the way of documenting a minor contract schedule or price change, or a required contract change that results from a force majeure event. So typically, these are further defined in your contract, and it's limited to minor price changes. So usually it's capped at a certain amount, like for example, 5% above the total contract value you may do via a change order, but otherwise through another method. This is usually change orders provide you with a quick path to making those minor changes to the contract that are necessary, and it's usually a lot more simple than executing a full amendment. And the result of a change order is that the contract is changed based on the terms of the change order. In contrast, an amendment is any other time you're changing a contract, you need to execute an amendment. So anytime it's not a minor contract schedule or price change, or if it's a change to the material terms of the agreement itself, then it needs to be an amendment. Amendments have to be in writing, signed and approved by both parties, and the result of an amendment is the same as the result of a change order. It just means that the contract is changed based on the terms that are in that amendment. So this is just to reiterate kind of what I already said, which is when are force majeure and change order language important? And it's important to think about including these when your schedule is very important to you, when you have a strict schedule, or where you anticipate needing quick, minor changes to that schedule or scope of goods or services. Where you have these factors, it is really important to consider adding the force majeure and change order language. It's also important to remember and keep in mind that your local contracting rules may contain amendment parameters or approval requirements. So it's easier administratively often to execute a change order rather than a full amendment. And always refer to your local contract rules about when an amendment is or is not permitted. So here again is just some sample language to show you what these sections may look like in an agreement. You can see here the amendment language, the catch-all, very simple. It just says that you can only change the language of this contract by written amendment, which is signed by both parties. That is fairly standard. The change order language is a little bit more involved. It says that you can commit to the following without actually following that amendment process. Here, it permits a contract price increase no more than 15%. So that's the amount, that's considered a minor price adjustment in this case, or adjustments to the project schedule. Each of those may be executed via a change order. And then finally, you have this force majeure language. Often you will see in contracts that you review, a section is not expressly titled force majeure. You can just tell that it's force majeure by this long laundry list at the end of examples. That is very common for force majeure sections. This is no exception. You have various types of force majeure or types of instances that qualify as force majeure, such as civil disturbances, acts of government, epidemics, storms, casualties, fires, etc. The list goes on. The first section or the first sentence there just further quantifies and qualifies what can or cannot be considered a force majeure event. All right, another section, actually moving on from the body of an agreement to the legal obligations in a contract. So these are the ones that I believe are most often negotiated almost purely by legal, but it's still important to have a base understanding of what these are and why they're important in your agreement. And who knows, there are, all pieces of a contract are interrelated. So there's ways that each will implicate the other. So it's not so cut in stone that it's important to still understand. So the first of these sections are ownership rights. There are a few different ownership rights to consider, whether you're doing a goods agreement or a service agreement. In a service contract, you often have work product that is a result of that service that is provided to you all. Maybe there's an end document or report that you are having produced, or maybe there's just useful materials that result after the service is completed. It's important to ensure that the city has ownership of this work product, or at minimum has an uninterrupted license to use that work product, unrestricted license to use. This is important so that you actually can use that work product for the things that you intended to contract for and aren't actually restricted by some underlying contractor rights to that work product. The same goes for intellectual property. You may have a surface level right to the work product, but if the intellectual property underlying the work product is obligated elsewhere, that can be an issue. In the context of goods, ownership rights, the most important thing to remember and to consider is when title actually transfers to the public entity. So if you recall my previous mention of COB or FOB and CIF, that whole analysis is when title and risk transfers to the public entity. So, checking your agreement, seeing what conditions there are on title actually transferring to you, seeing if you have some sort of inspection right to inspect the goods before the title transfers to you, etc., is very important in the context of goods. So here's sample language for title for goods and also work product in the context of services. So here you can see that title and risk of loss don't transfer to the public entity until the public entity physically receives the goods, have had a chance to inspect the goods, and they have mutually agreed to a time and location to receive the goods. So all of those conditions must occur before they actually receive physical title and risk of loss for the goods. That is ideal. Then you see in the work product section, all work product belongs to the city, and otherwise the city has a unlimited license to any underlying intellectual property rights. All right, performance security. Performance security is less common in goods and services contracts, but it does happen on occasion if it's a really high value or specialized piece of equipment. Most often you'll see performance security in the context of public improvement contracts, such as, again, construction, reconstruction, major renovation. So it's important to have a base understanding of. Performance security is a legal document which is provided as an assurance from a third party, often a bank, that they will fulfill the contract's obligations in some way if the contractor defaults. So it's kind of like a backstop, ensuring that even if the contractor defaults, the obligations will be picked up by this third party. There are many different examples of performance security. Some of the most common are bonds. Again, you see this in the public improvement context, but payment bonds, performance bonds, public works bonds, those are all very common there. But there are many other types of performance securities, including letters of credit and more. If you're requested to use a performance security type in connection with your contract, or if somebody is pushing back on the terms of performance security that you already requested, please consider consulting with an attorney before you proceed with that. All right, so warranties and performance standard. These both serve as legal tools for the public entity to ensure that goods are delivered or services provided meet expected standards. There are two different tools that are used for that result, but in slightly different ways and with different outcomes. So warranties are an obligation to meet a stated standard for a stated period of time. There are many different types of warranties, but they primarily fall into two categories: express and implied. Express warranties have to be expressly stated in your contract, or else they do not apply. Implied warranties, from the name, they are implicit in every contract unless you expressly waive them away. So some examples of express warranties that you've probably seen in contracts include defects warranties, providing that a piece of good will be free from defects in design, material, and workmanship for a period of time. Another example is a performance warranty. Implied warranties can include a warranty of merchantability, fitness for a particular purpose, and more. And the result of a warranty is that if a good or service fails to comply with the terms of that warranty, the contractor typically must remedy the issue at their cost. So in that example of defects warranty, if a good is delivered and then during that 1 year period of time, the public entity finds that it is defective in design, materials, or workmanship, then the terms of the warranty obligate the contractor to repair or replace that defective piece of goods at their cost. That's the result of a warranty. In contrast, you have a performance standard in most contracts. Performance standards are a measurable standard to which the contractor must hold themselves when performing services or delivering goods. There are various standards that are accepted for performance, but the three most common are reasonable, commercially reasonable, and best efforts. Reasonable is the lowest of the standards. That's just what any other reasonable person would do. Commercially reasonable means any reasonable person in the same industry as the contractor. So using industry standard as a measure here. And then finally, you have best efforts, which means that the contractor must go above and beyond to complete the performance. Courts have held that even best efforts can require extra expenditure of funds. It's the highest standard that you can have in a contract. The result of one of these performance standards is that if a contractor fails to comply with that performance standard, it's considered a breach of the contract. So it serves as a backstop to all other stated requirements throughout the contract. It's a little bit harder to prove because, again, you're trying to prove this more nebulous concept of a standard, but it is an important backstop to include regardless. So this is some example warranty language in the context of goods. And you can see throughout this, there are a few different express warranties stated. It states that the product will be new, free and clear of liens, and also free of defects. Those are all express warranties that are called out in here. The fact that no implied warranties are stated or waived means that all the implied warranties I previously mentioned do apply. All right, and then here's an example of what a professional standard may look like in an agreement. In this case, they're using commercially reasonable efforts, which is that middle standard and also the most common to see in service agreements. You can tell that it's a commercially reasonable effort standard because it states that the contractor shall employ methods that are generally accepted and used in the industry in accordance with industry standards. That means, again, that you're using that industry standard as an indicator rather than any reasonable individual. And then you can see throughout this section, there are other additional objective requirements that are stated for the services, such as complying with all laws, obtaining all permits necessary, etc. So any breach of this standard or a breach of those obligations would be considered a material breach of the agreement. Right, indemnification and insurance. These are some of the most heavily negotiated sections of an agreement and also the highest risk. So it's really important to have a base understanding of indemnification and why it's really important to have in an agreement. Often these two concepts are bundled in a contract. Contractors will request that they serve as backstops to one another, but they do not need to be written that way, and they're not the same. So to illustrate the difference between these two, I will follow up on that hypothetical that I had mentioned before. So let's say from that earlier hypothetical, the city purchases that one service vehicle for less than 25,000. The car ends up having a sticky brake, and a city worker who is driving the car crashes into a citizen's newly planted tree, damaging it. It's sad. The citizen sues the city, requesting monetary damages associated with the damage to the tree. Setting aside other legal arguments and remedies that are, and only looking at the categories here, the contractor would take two steps. So first, if there was good indemnification language in the contract for us, for the public entity, the vendor would be required to step into the city's shoes for this lawsuit, defend the lawsuit on the city's behalf, regardless of the outcome, including all attorney's fees, and be responsible for all legal risk and the outcome associated with the lawsuit. So that is indemnification. It requires the vendor, in the event of a third-party lawsuit, to step into your shoes, handle the lawsuit from start to finish, and defend you, meaning take all the monetary risk, monetary obligation of defense. Second, and separately, the vendor could seek to cover some of that cost from providing that indemnification to the city from its insurance provider, up to their stated limits in their insurance contract. So as you can see, for the contractor, the insurance can serve as a backstop, but they are not required. There are times when maybe the contractor would rely on its insurance that don't involve indemnification, but definitely when it comes to indemnification, they're probably going to seek to try to recover some of that cost from doing an indemnification from their insurance provider. So that is the kind of the difference between the two. So here's a standard indemnification language that I like to include in contracts. Here you see you have indemnify, defend, and hold harmless. You're indemnifying not only the city, but also their various officials, officers, agents, etc. And you're indemnifying from all third-party claims in connection with this contract. Very broad. The only caveat to that is that the city does not require indemnification from instances where it's actually the city's fault, where the third-party claim is a result of the city's own negligence. And that's fair. They shouldn't have to defend you or step into your shoes where it's your own negligence that's caused the third-party claim. All right, default and termination. So these are ways, or a default is a violation of a term or obligation of the agreement, and termination is how you end an agreement before the term is actually complete. So for defaults, you have non-material defaults and also material defaults. An example of a non-material default would be perhaps a public entity paying an invoice 2 days late. Technically, you know, you were supposed to pay right on time, but paying it 2 days late is probably not going to have a material impact on the contract. It's not going to result in a lawsuit, most likely, and it's most likely not going to result in the parties trying to walk away from the contract. Material default, on the other hand, could result in some sort of lawsuit or termination of obligations under the contract. An example of that would be in a goods agreement, failing to deliver the good that was agreed upon. That would be clearly a material default. Sometimes they're expressly defined in the contract, but not always. Often you have to look at the full language of the agreement and the circumstances of like the reason why the parties entered into the agreement to fully understand what is a material and non-material default. And the consequences or effects of a material default are varied. Anything that is available at law or in equity can be pursued by the non-defaulting party. But most commonly, the results of default can be terminating the contract, some sort of suspension of work or payment, some sort of specific performance, which means you're requiring one of the parties to do something, provide something, etc. Estoppel, which means you're requiring them to stop doing something, damages, and more. There's many different results of default. Termination, there are two main types of termination, termination for cause and convenience. Termination for cause means that you have a reason for terminating. Maybe there was a material default. Maybe there is some other obligation in the contract, a reason why you can terminate. Termination for convenience is just as the name sounds. It means that you're terminating for any reason at your own convenience. You don't have to give a reason. You can just terminate at any time. Usually there are notice provisions associated with termination, either for cause or convenience. Usually for cause, you must provide advance notice to the party that is in breach and allow them an opportunity to cure before you actually walk away. And termination for convenience, usually there is also some sort of advance notice before you're allowed to walk away. So here is sample language again regarding termination. You can see in 10.1, there's examples of termination for cause. And then the rest of this section really lays out what happens as a result of termination, the steps that the parties are required to take, etc. And then in 10.4, you can see that's a termination for convenience right. It says that the city may terminate this contract upon 30 days notice to the contractor when it's determined to be in its best interests. That would be, in my opinion, a termination for convenience right. All right, damages. I'll go through this briefly. I mean, this is where lawyers live, but just to give you kind of a quick overview of damages, damages are a representation of the harm that was caused by one party to the other in connection with a material default under the agreement. So, someone didn't fulfill the obligations that they agreed to under the contract. What is the harm that you suffered as a result? There are many different types and categories of damages, but these are some of the most common. Direct damages are the ones that you probably see most often. Those are the damages that directly result from the breach. So, for example, in that situation where the good that you were promised is never delivered, the direct damage could be maybe the value of that good. Consequential damages are knock-on effects. Things that aren't directly, or damages that aren't directly a result of the breach, but may indirectly result from the breach in the future. So maybe an indirect result of failing to deliver that good would be a loss of future use. If you can somehow quantify that, that could be considered a consequential damage. There are also special damages. I'm not going to go through those for the purpose of this presentation, but if you have any sort of questions about liquidated damages, always feel free to reach out to me. And there are also certain damages that you're allowed to pursue at common law to essentially ensure that you're getting the benefit of the contract that you entered into and no one is unjustly enriched by they don't get some sort of unfair advantage from having that contract and then failing to fulfill some of the terms. So a quick note on limitations of liability. I will never add this to any of our template contracts. However, they are fairly common in large private contractors' contracts, unfortunately, if you are starting from one of their agreements. So a limitation of liability is just what it sounds. It means that you are limiting the amount that a particular entity is responsible for in connection with your contract, the amount of risk, the amount of cost, etc. You can limit liability in a number of ways. Two of the most common are capping the total value that a contractor may be responsible for, such as saying up to $1 million and nothing more is how much they'll be responsible for in a contract, or even restricting the type of damages that they may pursue. Anytime you see any sort of limitation of liability in the contract, I highly suggest running it by your legal team because it can have large impacts for risk, liability, etc. in a contract. Right, so moving on to that other section of contracts, which are the miscellaneous terms and boilerplate terms. First, you have what I refer to as the public contracting terms. These are unique, meaning that in a private context, if you've come from a private context, you may have never seen these before. If you're doing private to private contracts, these are never required. These are simply a requirement by the fact that you are a public entity entering a public contract. But these will be the same from contract type to contract type. So regardless of the good or service contract you're executing, these are the same terms that you should be including in each of those, regardless of the value, regardless of the subject matter. Some of these, this is a non-exhaustive list as well, so there may be other terms that apply, but some of these include keeping public records, a requirement that there be no liens or claims, tax law compliance, choice of law being Oregon, and more. And these are the ones that apply specifically to goods and services. There may be other requirements for example, public improvement contracts or other types of contracts. And then you have your boilerplate provisions. These genuinely should be the same in every contract you sign in a perfect world. These are they're called boilerplate because you just copy paste them from contract to contract, essentially. These are still important legal requirements, but I consider them just part of your template. I have a list here, again, it's non-exhaustive, but these are some of the boilerplate terms that I expect in every contract, including a reference to permitting electronic signatures, a statement that's of severability, meaning that if one clause in the section or in the agreement is unenforceable, the other sections still have effect, and more. If you have specific questions about boilerplate provisions, I'm always happy to talk about those. Then you have your signatures page. This may seem a little bit as an afterthought for some people, but it is still very important because an agreement is not valid and binding unless it is fully executed. And fully executed means that both parties to the agreement end up signing. Unfortunately, I have had situations where, I've done a full negotiation on a contract. We think we've got to a great, point, a great place between the parties. We have a final execution ready version. We share that with the parties. And then I never hear from the public entity again on that particular contract. But then a year later, I am asked to return to the contract and do a contract interpretation. And I notice that the contract was never fully executed. This is very unfortunate because technically you don't have a legally binding agreement at that time, which at minimum is just awkward, right? It's better to just ensure that you take that final step, you get the contract fully executed. And then just as a note, as far as your local contracting rules, consider adding signatory requirements there because that is helpful. It means that it says that all city contracts must bear the signature of an authorized representative, which means that if someone is acting outside of their authority and executing agreements, you can easily just point to your rules as a reason why that contract may not be authorized and effective. All right, and then the final section in a contract are the exhibits. Exhibits are actually a binding part of a contract, but they supplement the terms of the body of the contract by providing further details. For example, in that context of scope of work, there might be a whole separate scope of work detailing the services that are being provided, or a project schedule, etc. Those are all parts of the contract itself, though, even though they're simply attachments. The one part for drafting that's important to note is the order of precedence of those exhibits. So you can see in this example here, I have listed out the order of precedence by the order that they're listed below. So that means that if there's any sort of conflict between those exhibits and the body of the agreement body itself is the priority. That's where you look first, and then you look at the exhibit A, exhibit B, etc. And that helps in case you have unclear terms or some sort of conflict between provisions. All right, it was a lot, but that is everything. I appreciate all of your time. This is my contact information. We are updating our emails very soon, I believe in June. So this is my new email address. My old email address will still automatically forward to this. And I do have some time for questions. So if anyone would like to ask questions, I think the best way to do this probably will be Kristen, if you can tell me if people have their hands raised and maybe unmute them, we can ask questions in that way. Or otherwise, if no one has questions, we can also just end early.
I don't see any hands raised.
Great. Well, I appreciate everyone's time. If you do have specific questions that you would like to ask, maybe they're more personalized and you don't want to ask them in a public meeting like this, you're always welcome to reach out for me via email or phone. And I am available for specific trainings as well, if you have any sort of specific trainings that you would like on public contracting or anything else. So I appreciate everyone's time, and thanks again. I look forward to seeing you all soon.
Thank you.
Thank you.